Hi, Brian Hengesbaugh, partner at Baker McKenzie in Chicago and Global Chair of Privacy and Security. We're here for part 2 of our series, What Does the California Consumer Privacy Act Really Mean for Human Resources Data? In part 1, we had a bit of a brief introduction, and now we're moving into part 2, which is we're going to look at notice and choice as applied under CCPA in the context of human resources. So the starting point is the notice obligations, fairly comprehensive notice obligations. Think we haven't had to provide to our employees, our contract workers, our other workforce members any kind of a privacy notice before, like we had to do, say, in Europe under GDPR, but now we've got that obligation. So a comprehensive set of content you need to start providing in the context of a privacy notice, including information about the categories of personal information that you collect, the sources of the personal information, some pretty rigorous detail around sharing of personal information. 2 different groups, situations where you may sell personal data, and I know that sounds absurd, but just stay with me, and I'm going to get to that in a minute. Sell personal data to third parties, as well as situations where you just share personal information with third parties for other business purposes. You need to tell people about their rights of access and deletion, etc. And if you are engaged in the sale of personal information, then you're going to have to meet certain formalities in terms of content requirements and in terms of warnings about do not sell my personal information, clicking to opportunities to opt out. I know that sounds like a consumer set of issues. I appreciate that. I think the law was primarily intended to be focused on consumers, but it's been drafted in such a way that residents of California, including in their capacity as employees and otherwise, are going to be covered. So we're just going to have to deal with it. Looking at, and so to support that notice, by the way, you can tell you're going to have to do a fair amount of due diligence around what you're doing in terms of collection, use, sharing of data, et cetera, so that you can accurately describe in your notice what you're doing. In terms of choice, the concept of sale has been very broadly defined under CCPA to be any sharing of data for monetary or other valuable consideration. And you might say, well, geez, we're not selling our employee data. Well, I appreciate that you're not selling your employee data like somebody would sell a marketing list, for example, of consumers. But this definition is so broad, we know that valuable consideration is almost anything of value or anything that would induce somebody to enter into a contract. So you say to yourself, where could that come in the human resources context? Well, for example, if we have a vendor who's taking our employee data and they're doing analytics on it for their own purposes, basically, at that situation, it comes close to saying, gee, we might be sharing data for some kind of consideration. Maybe they don't give us an express reduction in our purchase price for the services, but nevertheless, you can see that that element is there. So what you're really going to want to do around choice, and if there is a sale, the consequence of that is you need to provide opportunities for employees to opt out of that sharing of information, which would be very challenging, I would say, in the employment context. And by the way, it's not just third parties. If you're sharing between and among a group, you have this of affiliated companies, you also have this issue. So what you're going to want to do is do some good due diligence and start to divide out the buckets of third parties with which you're sharing data or affiliates with which you're sharing data. You're going to want to look to be doing some amendments of service provider agreements to try to address the issue if indeed there's a secondary use that would be made by the service provider. One strategy, completely untested, but one idea would be if the analytics that the provider is doing comes back to your benefit, defining the sharing as for your business purpose and saying the service provider is doing that activity on your behalf. So that's one strategy. Another would be if you're sharing at the direction, and if you do have a service provider, by the way, that meets these requirements and you amend the contract accordingly, there is not an opt-out duty that comes into play for it. Another is sharing that's done at the direction of an individual. So here in the HR context, I think if the individual is having you share the data, for example, with a life insurance provider or something along those lines, maybe you can say that you're doing that sharing at the direction of the individual. There's still some formalities that go with that. There's still likely to be an amendment needed for your agreements with those third parties. And lastly, if a third party is receiving the data but is receiving no consideration for it. So for example, auditors that might be coming in and getting information, you can perhaps look at amending your services agreement with them to clarify that there's no consideration for the personal information that they're receiving. So those are some examples. One other example I'll just throw out to you that we've seen already is what about in the context of succession planning or talent management where data is being shared between and among affiliated companies. They're all contributing, for example, to a pool of information, and then they draw from that information to decide if there's somebody that they want to offer a new type of job to. That looks closer to valuable consideration for sharing, and you might consider giving some sort of opt-out opportunities. That would be consistent with how that type of issue has been handled under GDPR. But these are all the types of questions that you need to grapple with and figure out how you're going to approach, again, with the end game in mind of limiting the circumstances where you're going to need to provide opt-out. Thank you.